Ms. Lewis?
Yes.
You're gonna take that third row all the way to the end. And you're gonna sit in the chair next to you're gonna sit in the second chair.
Okay.
You're gonna sit next to Mr. Lewis, that's Mr. Davis. Mr. Minot, you're gonna sit next to Mr. Davis. Sir, you need to take your hat off. You're gonna sit next to Mr. Minot, that's Mr. Filino. And Ms. Landry sit next to Mr. Filino, y'all, excuse me. And Ms. Caraway, you're gonna sit next to Ms. Landry. Ms. Reynolds, you're gonna walk up to that first row of chairs. You're gonna sit in that first chair in the second set. And Mr. Julian, you're gonna sit next to Ms. Reynolds. Sit next to Ms. Reynolds. Ms. Darcy, there's a seat between you and Mr. Holt. Right there. Is that Butcher or Boucher?
Boucher.
Mr. Boucher, you're gonna sit next to Ms. Darcy. Ms. Evick, you're gonna sit next to Mr. Boucher. And Mr. Allen, you're gonna sit next to Ms. Evick, right here. Yes. Mr. Coleman, you're gonna walk down that second row of seats all the way down to that second set, all the way down. Just keep walking. And you're gonna sit in the second chair. And Mr. Davis, you're gonna sit next the second chair. That's the first chair, right? Okay. Yeah, right there. And you're gonna sit next to Ms. Baker. Ms. Ong.
Yeah.
You're gonna sit next to Mr. Davis. Right there. Just keep walking. Sit next to Mr. Davis, next to Mr. Davis. Mr. Davis is right there. Okay, now you have just keep walking. There's a seat in between Ong and Dow. And right there, Mr. Dow. Is your name pronounced Dow or Dope?
Dope.
Dope? Okay, excuse me.
Number 19, Mr. James E. did come in.
Okay, he's here.
If the message was received, this is the one that was excused for family emergency.
Okay, so is he?
Yeah, I was gonna come and just get them out.
Okay.
Cause I didn't want to.
Hold on a minute.
Trouble.
Why don't you come on up? I don't see what's this. Oh, a minute, hold on. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes, and I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon for inclusion on a criminal jury trial. In this court, we handle criminal cases, but they're considered they're misdemeanor cases. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, you will be examined for inclusion on this misdemeanor criminal case. Our courtroom hours vary. They're normal court hours is usually from 9 to 5, 9 a.m. to 5 p.m. However, in County Court at Law Number 2, Jefferson County, Texas, at 9 a.m. Monday through Fridays, we either have a jury docket, trial docket, we have a pretrial conference docket, we have an announcement docket, and on Wednesdays, we have our motion to revoke probation docket, and along with an announcement docket, and on Tuesdays, we have our arraignment docket. Now, most of the time, or most days, those dockets usually start, they start at 9 and they normally extend past the lunch hour. It's not unusual for us to be in court 1 o'clock, 1:30, 2 o'clock from the 9 a.m. docket. And so what we normally do when we have our jury trial dockets, we have the jury trial dockets in the afternoon at 1:30. And so our trials will start at 1:30 until usually 5. And we usually have, we would allow you to, or you'll be permitted to separate for recess, for meals, and at night. Now, if you're selected on this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. Whether or not you're selected as a juror today, you're performing a significant service which only free people can perform. At this time, I must administer to you the first of 2 oaths. And I need every one of you to raise your right hand. And once I finish administering the first oath, I need everyone to say, "I do." Do you and each of you do solemnly swear or affirm that you may make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as jurors, so help you God? Please say it. Okay, you may put your hand down. Now, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way that I'm going to ask the questions, I'm going to ask a series of questions. I do not want you to answer each question out loud. Just answer the question to yourself. And then once I finish asking the last question, I will state, well, I will ask, is there anyone disqualified under the law based on your answers to the questions that I previously asked? If you think that you may be disqualified under the law based on an answer to one or more of the questions, then I would ask you to raise your right hand, and then we will discuss that matter privately. And when I say privately, it's outside the presence of the other jurors. We would ask that you will come up before the bench. We're on YouTube. I'll turn the YouTube off. I'll turn this microphone off. And I'll put this noise device on. And then we'll discuss the matter more privately. Okay. So I'm going to start with the first question. And the first question is, except for failure to register, are you a qualified voter in this county, that is Jefferson County, and under this state, which is Texas, under the Constitution and laws of Texas? Have you ever been convicted of a theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? And I usually pause at this question because I need to explain to you that I'm required by law to ask this question. I'm not trying to pry into your own personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law based on the answers to those questions, just simply raise your right hand. Okay. We have one person that's is that Jeremiah Minot? Okay. Mr. Minot, would you please come forward? Okay. Okay, ladies and gentlemen, is there anyone else on the panel who think that they may be disqualified under the law? Okay. Now I will determine if anyone who is otherwise qualified to be a juror in this case would like to claim one of the following exemptions. And you may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, just continue to remain seated. And I'm going to ask a series of questions. Again, I do not want you to answer them out loud. Just answer them to yourself. And then once I finish asking the last questions, I will ask if there's anyone here who would like to claim one of the exemptions. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the 3-year period before today? Or are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? Is there anyone here who will be claiming one of the previous mentioned exemptions? Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. With the excuses, I will not ask a series of questions. I will make 3 statements. And then if you think that you would like to claim an excuse based on one of the statements that I make, just please raise your right hand. First statement: a juror may be excused for observance of a religious holiday upon completing an affidavit as required by Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here who will be asking for an excuse? Okay. Let the record reflect that no one is asking for an excuse. No one is claiming an exemption. Somebody's hand is up? Okay.
Can I just have clarity on what does that mean? The impartial, do we know the?
No.
No more if it depends.
Okay, let me read the question again. I mean, the statement again. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial, may be excused. So if you have trouble listening to testimony, and if you cannot be fair and impartial, you can be, you can be excused.
Can I-
Yes, you can come on up. We can discuss this matter. Hold on a minute. Come on up. Is there anyone else who would like to claim an excuse? Okay. Let the record reflect that the juror number 13 has been excused. Let the record reflect that juror that no one claiming an exemption. Juror number 4 was not qualified. And let the record reflect that the remaining members of the panel who is now seated is qualified to serve on this jury. Let the record also reflect that the court is convened in this case, cause number M323227, the case is styled the state of Texas versus Samuel Hayden Falk. Falk is currently charged with driving while intoxicated. The defendant's counsel, the defendant for the state, and all members of the jury panel are present. Now, ladies and gentlemen of the panel, you have been summoned here as prospective jurors in a criminal case. The defendant in this case is Mr. Samuel Hayden Falk, who's sitting before you. Mr. Falk is represented in his case by his attorney, Attorney John Macy. The state is represented by Assistant Criminal District Attorneys, Attorney Haley Simmons, and Attorney Andrew Hubel. The court reporter in this case is Miss Ada Christie. She's sitting to my left, and she will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff, Miss Brenda Mosby, she is sitting at the bailiff table. You met her earlier. And as I mentioned earlier, the defendant in this case stands charged with driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you prefer not to answer certain questions in the presence of the panel, just say so. And I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready to proceed? Okay. The panel is yours, Ms. Simmons. You have 30 minutes. If you need more time, just let me know and I'll give you more time.
Thank you, Judge.
You're welcome.
All right, good afternoon, everybody. How many of you were excited to come in today? Raise your hands. Nobody? I see you, really good. You as well? I'm guessing everybody else is not excited to be here. Did anybody get that letter in the mail just dread coming up here? Okay, I see it. I'm gonna try to change y'all's mind, okay? First and foremost, I appreciate y'all coming in here today. Again, my name is Assistant Criminal District Attorney Haley Simmons. Does anybody know myself personally? Nobody? Does anybody happen to know 88 Andrew Hubel? And what about the defense attorney, Mr. Macy, or the defendant? Nobody knows anybody up here? Okay. So again, as Judge says, we have our lovely court reporter here today. I do ask if you're called upon or if you have questions, kind of speak up so she can hear you, okay? Sometimes maybe state your name prior, or you can hear your number, at least she can hear for the record for you, okay? So as you can see, we are here for driving while intoxicated, Texas Penal Code 4904. my board and I are just gonna go through, and by the way, that's a fancy word for jury selection, or in this case, deed selection, okay? So follow along with me. What we have here is the offense. A person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. So this is kind of the law that this is the law that you're gonna abide by if you're selected as a juror. Now, when you're going through it, there's a lot of misconceptions as to what accounts for DWI or what accounts for intoxication, or maybe some people get the words drunk and intoxicated confused. So I kind of want to clarify that from the get-go. Does the defendant have to be drunk to be part of the DWI? No, that's Ms. Jones. Okay. What do you think is necessary?
I think, just being over the legal limit, just drinking or using drugs and operating motor vehicle.
And you say just over the legal limit, is there anything else that you might account for?
Or using any substance and getting behind the wheel of the car.
Good. Yeah, perfect, thank you. Okay, by the way, I'm gonna pick on everybody, I'm gonna try to get to each and every one of you, okay? Sorry. Don't feel left out if I forget you, I'll probably come find you. The secret is not to be quiet, you should be on the talk, ask questions, so talk with me, we'll have communicative process, okay? So the defendant has to be intoxicated, kind of like Ms. Jones was saying. And what intoxicated means is not having the normal use of his or her mental or physical faculties by reason of the introduction of alcohol and or drugs, or BAC of 0.08 or higher. Now, we see the word "or" a lot there, Mr. Davis. Does that mean we have to have all three to satisfy?
Not sure.
Not sure? Okay. So that's gonna bring me to my next point. Intoxicated in Texas. Now, what you're looking at here is it's separated by 3 bullet points. Not having the normal use of mental faculties, again, by reason of introduction of alcohol or drugs into the system. Point 2, not having the use of physical faculties. Then we go to that last one, having a blood alcohol concentration of 0.08 or higher. So these are different terminologies, different definitions of what intoxicated is. So with that being said, the state doesn't have to prove every one of them. We just have to go through and you have to decide as a jury whether or not we have proved either mental or physical faculties have been lost, the normal mental or physical faculties, or whether or not the blood has a concentration of 0.08 or higher. So if you're selected as a juror in this case, the evidence presented to you, you'll be able to make that determination. Does that make sense? We don't need all. Does that help clarify, or
Yes.
is everybody on board with that? Okay. Why do we have 3 definitions? We kind of skipped ahead of that, okay? Different things we're looking at. Normal physical faculties as far as mental, maybe slight alteration. Can somebody think of physical faculties that might be altered if someone might be intoxicated? Is it Mr. Filio?
Yes. What's the question again?
Physical faculties, what are some that we may see that might be altered if someone's intoxicated? Okay, reactions. Ms. Landry, what would you say? Can't see? Okay. Having trouble seeing, maybe blurred vision, things like that. Okay, everybody can agree with that? And some of this might sound repetitive, I'm just drilling, making sure we all understand the actual definitions or to abide by. So going to this next one, does this look familiar to anybody? Kind of hoping it would. Revenge of the Nerds. The mid-1980s classic. If you're too young, I'm sorry. I myself am, so. Anybody kind of compare between Lewis and Ogre? We see any physical differences between the two? Got small little old Lewis, and we have very eager Ogre right here. So we have Lewis, who weighs 145 pounds, never had a drop of alcohol in his life. Until his wedding day. He has had 2 glasses of champagne, speech is slurred, poor balance, inappropriate comments. Mental and physical faculties not normal, and the BAC is under 0.08. He clearly does not have the normal use of mental or physical faculties, but his blood is below 0.08. So with that information, who am I gonna pick on that one? Carol? Would he be intoxicated by the definition we just went over?
Yes.
Okay, which bullet points on here would help you? And I can read them out loud, I know it's.
Yeah, I
I'm
can see
sorry.
it fine.
Would you say speech being slurred,
Yes.
that's a loss of mental or physical faculties. Poor balance, inappropriate comments. So these are things we take into consideration, and you as the jurors, if you're selected for this case, you'll look at and you'll take into consideration in determining whether or not those physical or mental faculties have been altered by any means. Let's talk about Ogre. He's a professional drinker. He weighs 250 pounds. He has been drinking since he started shaving at 16 years old. He drinks about 2 to 3 pitchers by himself without slurring or stumbling and has a very high intolerance. Or tolerance, I apologize. Normal use of mental and physical faculties. I mean, he's not slurring his speech the way Lewis was. He's not all over the place. He's walking perfectly fine. But his VAC is way over 0.08. Ms. Reynolds, have we met the element, or not the elements, the definition of intoxication? Is it by blood or is it by mental or physical faculties? Blood, good. Would you agree with that? Is it Julie? Julie, oh, I pronounced it. I was worried about that one. So you would agree with that? Okay. And again, we're looking at the mental and physical faculties here or the blood? Good. All right. Which one is intoxicated under Texas law? And again, we've rolled this in. I know it says both, but we kind of have to agree. Mental, physical, and blood. Texas law says neither Lewis or Ogre should be operating a vehicle, regardless that one was the blood and the other was normal physical and faculty, or physical and mental faculties. Okay. Again, we're going back to this. We're all gonna get it by the end of the time we're done. Ms. Dorsey, which one does the state have to prove? Just one. Okay. A little more personal questions here, and if you feel that answering this question is too difficult, you can ask outside of the presence of everybody if necessary, okay? Has anyone in this room known someone that has been arrested for a DWI? You have? Is that something you'd be willing to share with us?
I've had several friends.
Several friends. With that being said, is it something that would affect your ability to be fair and impartial?
Possibly, yes.
Okay. Okay, what was your name?
Ryan Davis.
Thank you, Mr. Davis. We'll come back to you, okay?
Who's here?
Where's Ms. Caraway? I'm sorry, Ms. C.
A relative.
Relative, would that affect your ability to be fair and impartial in this case?
Yeah.
Thank you. And I appreciate everybody's honesty from the get-go, okay? Does anybody know someone that has possibly been hurt, injured, or worse by the actions of the drunk driver? Okay, we have juror number 2, Tracy Lewis Jones. Okay, and juror number 9, Warren Jolin. Okay. Is that something you'd be willing to expound on a little bit?
My best friend was killed out of that.
I'm so sorry to hear that, Ms. Jones. Would that affect your ability to be very confident? And what about you, Mr. Jolin?
I was 3 years old, I lost my brother.
I apologize for your loss. Would that affect your ability to be fair and impartial?
No.
Okay, you'd be able to look at the evidence before you and weigh those independently. Okay, thank you again. I appreciate y'all's honesty and we'll come back to you, okay? Anybody else? Had a loved one affected, a friend? That is really hard to see, guys, and I apologize. I'm gonna read it out for you. Kind of talked about this a little bit. Has anyone ever been around somebody that's intoxicated? Pretty much everybody? Okay, okay. What do y'all see? And again, everybody's different. We saw Lewis and Ogre. What do you see? Well, here, I'm gonna go in order, so I'm gonna get everybody before we're done. Can we start with Ms. Dorsey? Yeah, okay, you're out of this one then. Boucher, did I get that right? Okay, what do you see when you're around somebody that's possibly intoxicated?
You're making fools.
Okay. Does everybody agree with that? Is everybody always making a fool of themselves if they're intoxicated?
No,
No.
that's
Not all the time.
Not necessarily, okay, so everybody reacts differently, right? Sometimes we can call that whatever tolerance, maybe tolerance is the word, that's usually easier way to compare it. So making a fool of themselves, I like that one. Mr. Allen, what would you say if you've been around somebody that's intoxicated?
Married to one, and I was in the Navy for 20 years.
Okay,
I
what is,
found that that's truth serum.
it's truth
You
serum.
Find out how somebody feel about you.
Okay, so we have actionable and truth serum. Anybody have anything else that they see, maybe on the physical side, physical property? Faculties? What's that?
Slurred speech,
Or
stumbling.
stumbling, good. Would everybody agree with that? Okay. All right. How did you know y'all are right on their smell? Balance, like I said, stumbling, speech, judgment, actions. Does everybody agree that these are things we can look at and we'll be able to assess whether or not someone might possibly be intoxicated? Possibly. Okay. All right. None of these signs require expertise to identify, and this is my favorite two words. It really just requires common sense. So we see people, we interact with people daily, we're able to see the way they respond to you, talk to you, stumble to you in a case of possible intoxication, like you said. So we would all be able to look at all of these and put them together and determine whether or not we could see intoxication, correct? Everybody feels they're on board with that. Okay. What would you like to see in a DWI trial to determine whether the defendant is guilty? We're making our way up here. Ms. Baker? What are some things you would like to see?
Well, kind of like you said earlier, one of the three things,
Okay,
either the blood or,
so what, you said the blood, what other evidence you think?
like a video or something like that, where we could see some of the physical signs or something like that.
So everybody would like to see blood, video, things like that. Right, everybody agrees? Okay. So we have in-car video, good. Crime scene investigation, everybody watch CSI, have in the past, no? Okay. That's where you read, but. And then we have types of witnesses, let's see, Michael Davis. What are some types of witnesses we might see in a DWI case?
The ones that look like they're at the same
They're the scene? Okay. Who might that be?
area. Person that maybe that had got wherever that one was, yeah,
And I just want to clarify, is your name Brian Davis?
Michael.
Brian, okay. Your number 17, what's your name?
Brandon is.
Okay, are we both Brian Davis or Michael Davis?
I'm Michael.
Okay,
I'm Brian.
okay, that's what's happening here. All right, y'all are right beside each other. So, Mr. Davis, you're number 17. What about you? What kind of witnesses?
What was the question?
What type of witnesses would you expect to see in this case?
The accused, if there's anyone else in the car.
Okay, when you say the accused, are you saying the defendant?
Yes.
Okay, would it surprise you that the defendant doesn't have to testify?
No, it wouldn't be surprising.
Okay. I just want to let everybody know that the defendant does not have to testify. That's actually a constitutional right they have to themselves. So does everybody feel that they could be fair in not holding this case? Because not proving the burden whether or not the state, if the defendant was not to testify, is that something you would take into accountability in determining guilt? Are you saying yes?
Maybe.
We'll come back to you, number 17. What about 7? Am I saying that right?
Yeah, I go by Erie, but that's
Airy?
Erie.
Okay. I will remember that. I like that. So types of witnesses. What about you?
The officer,
Officer, okay. Maybe someone just near the event that happened to see it. Okay. So we have, really hard to see, and I apologize. We have our eyewitnesses. And like you said, we have our police officers. Again, I know that's hard to see, so I'm just saying it loudly so y'all can hear what's written down there. Now, I'm gonna stay on the area. What kind of, or how do we treat each witness that may take the stand? Do we treat them the same? Do we treat an officer with higher credibility? Do we start at the same level?
yeah, they're all the same. I mean,
Good, good. That is the exact answer. Again, difficult, I apologize. We treat all of our witnesses exactly the same when they're in a stand. We are not to give any higher credibility to an officer. We're not to give any lower credibility. What you'll see is whenever we start testimony, you're going to be able to watch somebody's demeanor on the stand. So that's things you as a juror, if you're selected, get to take into consideration. The way they're responding, eye contact, you have the ability to assess their credibility. So we can all agree that we start with the same credibility on each witness, and from there you may potentially change that line. Does everybody understand that? Okay. So again, every witness in a criminal trial should be treated the same. This is kind of just going on police officers as witnesses. They're not special witnesses. They're not to be given any type of extra weight just because they're on the stand testifying as an officer. And they're not perfect, and we all agree that officers can make mistakes as well. Does everybody understand? Does everybody agree with that? All human, okay. Standardized field sobriety tests. Does anybody know what these are?
Yep.
Okay. Let's see, Mr. Doe. Did I pronounce that right? Okay. Do you know what standardized field sobriety tests are? No? Okay. So everybody see them maybe on TV, on like a TV show or something? Okay. So what these are divided attention tests. Standardized keyword there, they are standardized in nature. Why are they used? Does anybody know without reading why we might use standardized field sobriety tests? Nobody? Okay.
Only for they actually get to the station or wherever, before they do the blood and testing, they do a sobriety test on site of stopping,
So what are they looking for? Clues possibly?
Yes.
Right, okay. So driving requires, and that's why we use them, driving requires us to basically multitask. When we're driving, how many things are we doing? Should be texting, right? We should be focusing, maybe using our blinker or checking our mirrors, things like that. It's a divided attention task. So we use those standardized field testing to actually, the sobriety test, I apologize, to see whether or not they are functioning properly as far as they have the divided attention skills that are necessary. And then the cops are using those as clues in determining how they proceed. So that's a perfect answer. Thank you. So 2 seconds late on the brakes can mean rear-ending another car. Turning the steering wheel 1 inch can mean the difference between side swiping or maybe just going off the road in general. So when we're driving, we have multiple things we're focusing on, and that's why we use those standardized field sobriety tests. So as we talked about, and we're getting near the end here, I promise. Texas legal limit is 0.08. Everyone is impaired in their ability to operate a motor vehicle. If we haven't reached a 0.08, or potentially we see somebody with the normal and mental, physical faculties that have been altered, we have all agreed that there's still possible intoxication, correct? And again, we get to that with the revenge of the nerds, Lewis and Ogre. Okay. The defendant, I really want to key in here. The burden, nothing. The defendant has subpoena powers, right to discovery, right to trial, right not to testify, and then the right to defenses. Does everybody understand what these mean? That the defendant does have rights in these cases? And kind of like we were speaking, Mr. Davis, juror number 17, would you still hold it against the defendant if he were not to testify in this case?
No.
Okay. Presumption of innocence. Who has a presumption of innocence? Here we go. You almost said no, didn't you?
Oh.
Okay, and that's Julian, number 9, okay. So everybody has the presumption of innocence, that is absolutely correct. That means the state has to prove that the defendant is guilty beyond a reasonable doubt. So as he's sitting here right now, does that mean he's guilty?
No.
Good, everybody agrees with that. Good. All right, reasonable doubt. Really want to key in here. Texas law requires the state prove its case beyond a reasonable doubt. Does not allow us to give you a definition of this term. Does anybody think that we should be obligated to give you a definition of reasonable doubt? Does everybody understand that this is a burden that you will come to reach whenever, if you're selected as a juror in this case? With all the evidence presented to you, you will make that determination. I cannot give you a definition of reasonable doubt. Does everybody understand that? It's not beyond all doubt. That would require you to be there. You would have been an eyewitness. You would have been at the scene somewhere hiding out. I don't think any of you were. It's not beyond a shadow of a doubt. And it's not beyond an unreasonable doubt. Best explained, you will know it when you see it. Or my 2 favorite words I talked about earlier, common sense. So when you have the evidence presented to you and you make that determination, you'll use all the evidence and you will make the determination on whether the state has met its burden. Does everybody understand that the state is the one required to meet this burden? It's not the defendant, it is myself. The jury's duty: decide the facts, apply the facts to the law, And then you're gonna follow the law. Does everybody feel that they can follow the law presented to them? And everybody can be fair and impartial? Okay, let's see, I'm gonna pick on one more person, I'm gonna do another one here. See. Do juror number Allen, Michael Allen, number 14. Do you feel it's important that the state prosecutes these type of cases? Okay, does everybody agree with that? Does everybody feel that it's very important that the state prosecute DWI cases? Does everybody feel that it's not important? Anybody? And does anyone feel that they cannot sit in judgment of another for religious reasons or maybe any other reasons? I'll just ask one more time, who here would not be able to be fair and impartial? Okay. Any questions for me before I sit down? All right, I thank y'all so much for your time. I appreciate you taking the time to listen to me today, and again, I look forward to presenting this case to you.
Mr. Macy, the panel is yours.
Good afternoon, ladies and gentlemen. My name is John Macy, as I told you, and I'm the attorney who represents Samuel Paul, and he's accused of DWI. So I wanted to ask you, first off, what do you think a juror's job is?
Review the facts collected, review the evidence collected, and make the informed decision on guilt or innocence.
That's a very outstanding question. I don't know if y'all could hear what she said. I doubt you can, because I barely heard her. Of course, I wear hearing aids. As I understand what you said, and you're, I'm sorry, you're Miss Lewis, right?
Yes, Louis Jones.
Oh, Ms. Jones, okay. Tracy Lewis Jones. You said, if I heard you correctly, that you're supposed to listen to the evidence and decide which parts of it you believe and apply the evidence that you found to the law and reach a conclusion as to whether or not they proved their case beyond a reasonable doubt. Is that right?
Right.
Okay. Does anybody disagree with them? So how do you do that?
You have to be impartial.
Yeah. So, and I know that's a vague question. When you came in here, you didn't know what kind of case it was. You just knew that you were called for a jury. And so now you know there's a DWI case, right? And Samuel's the one who's accused of it. So if you had to vote right now, would Samuel be guilty?
No,
Okay. And Mr. Davis, you're next. Is Samuel guilty?
No.
I'm sorry.
No,
Ryan Davis. Is that number 17, right?
that's me.
Okay, so Michael Davis is number 2, 3. You're right there. Okay. Okay. All right. We supposed to have your names on here, but they're not right. Michael Davis is right there, and behind you is Brian. That is right.
So you're saying Brian Davis is in the
Brian
wrong?
Davis is number 17.
Okay,
And Michael Davis is number 3.
okay, well, let's correct that right now. Pepsi.
So, let me just say, let me see this show of hands. For everybody, just raise your hands, if you have, how many of you think he's guilty right now? Okay, so I don't see anybody's hands. Okay, so how many of you think he's not guilty? Right, so what does that mean?
He's innocent right now.
So right now, he's not guilty. Right. And I really appreciate the fact that almost every one of y'all raised your hand when I asked you that second question. Because most of the time, when I do jury trial, and I ask that question, people just stare at me. And they don't raise their hand. They don't, I ask them, is he guilty? And they don't raise their hand. I ask them, is he not guilty? And they don't raise their hand either. But in the United States, you're innocent until proven guilty. So your answer should be what you said, which is he's not guilty. Because you haven't heard any evidence at all. The only thing you heard was that he's accused of something. But is being accused of DWI, I mean, you're guilty of DWI. Does anybody think that it does? I don't see anybody's hand. And it's difficult. And I think Ms. Simmons touched on it in a way. We're used to sizing people up, right? We do that all our lives. We meet them. And it's almost like a protection mechanism, right? You meet somebody and you can tell whether you feel danger or not, right? You might have preconceived notions of certain things, like you see somebody and they don't look like, or something gives you a bad vibe, or whatever you want to call it, and you're kind of keeping one eye extra on them, make sure you're safe, right? Human nature, size people up. We're in trial, okay? And so what happens in the dynamic of the trial? The state has the burden of proof that Mr. Paul was intoxicated while he was driving. Okay. That means that they're the ones that are going to put on all the evidence first. Right? And y'all are going to hear all of their evidence. And what's very difficult, in my opinion, is for you not to decide whether Mr. Falk's guilty or not before you've heard all the evidence. The way a trial works is the state puts on evidence. I may or may not put on it. Because I don't have a duty to prove that Mr. Falk isn't guilty. They have the burden of proving that he is. Okay. So I may or may not put on testimony, I don't know. But then, and Ms. Simmons kind of told you what she thinks the statute says. And I'm not suggesting that she's lying to you or anything, but ultimately what's gonna happen is that well, you're gonna end up getting put on the jury, with the ones that do. And then you're gonna get sworn in. And then Ms. Simmons is gonna put on evidence. And then, I may or may not, she's gonna ultimately rest. And then I may or may not put on evidence. And then the judge, once the child part, the guilt innocence phase is over. Because that's how it works in Texas. There's two phases. There's a guilt innocence phase. And then if someone's found guilty, then they go to the punishment phase. But you don't really know what, at that point, the only thing you're gonna have is the evidence that was presented to you. But you don't know what the law is yet, that you have to apply it to until the judge gives that to you. And so once the judge gives it to you, then you'll know, okay, now I have the evidence. Now I know what the law is I'm supposed to apply it to. And I'm gonna go and be sent back into the jury box, jury room, pick a foreman, and then deliberate and determine whether or not Ms. Simmons reached, proved to you beyond reasonable doubt, everything. And so the reason I said I think it's difficult is because people tend to want to, because of human nature, they tend to want to size people up and make determinations on people fast. Because that's what we do in real life. But we're in a jury trial. And so the hardest thing, in my opinion, we all do is to wait until you've heard everything, both the evidence that Ms. Simmons is going to present to you, and then evidence if I produce anything. And then ultimately at the end, you're gonna hear our arguments as to why she thinks she proved it and why I'm gonna suggest that she didn't. But what we say doesn't matter, because it's not evidence, it's arguments. It's the evidence that you're gonna hear. And what is evidence? What is it, Mr. Billiot?
Yeah.
Where'd the evidence come from? You know?
Yes, evidence to come from.
Well, yeah, you said, I don't know if y'all heard it, you said the evidence comes from the officer. Okay. That's one thing. Basically, in a jury trial, or in a trial at all, evidence can be testimonial. In other words, somebody saying what they believe they saw. Okay. Well, the jury, you decide, do I believe what they say? Or do I believe some of what they say? But I'm not quite sure I believe it all, or I don't believe anything. But that's up to y'all, but that's testimonial. Then you have what they call, there's physical evidence, right? Right. say the evidence was important, that there's a pen, kind of a whitish pen with a black tip. It's physical evidence you could get. You could maybe believe if that was important or not, but that's physical evidence. And then there's what they call demonstrative evidence, which is kind of evidence that maybe is say a gun was important, but there was no gun, but there was a picture of a gun. Then that might be, well, that's what they call demonstrative evidence, but the point being that that's what evidence is, and you're gonna hear that. From the stand, but the only thing that you're supposed to consider is the evidence that's submitted by the judge. So if she finds there's evidence and I objected to it, and the judge sustained my objection, which means he agreed with my objection, then the evidence that she wanted to produce isn't admitted. And if it's not admitted, I can't consider it. And so that's a very difficult thing to do. It's very difficult. Say hypothetically, this was a drug case, and there was officer illegally searched and found 100 pounds of heroin in the trunk. He's sitting there with 100 pounds of heroin. And here it is, right here in front of you. And the judge was like, I found that that's illegal. The search. And so the heroin's not in this. What would if you needed the heroin to prove the person was guilty of, say, possession of heroin, what would the verdict happen? A hard thing to do. Your verdict should be what? No. Yeah. What's your verdict have to be? Not guilty, which is very difficult. Now, of course, we don't have something like that. And quite frankly, that's rare because chances that happening are slim, but at any rate, I say that just to stress to you that, you need to wait until you know what evidence was admitted and what the laws say about it. Because if the laws later say all of a sudden that if you think that the police officer illegally searched, you're supposed to not consider the 100 pounds of heroin, then that's what you maybe should do. But you don't know that until you see it. Until the judge tells you what the law is that you have to follow. And I kind of went off on a tangent. So let me ask you this. How many people have been accused of crime? Two people were raised their hands. So the rest of you never got pulled over for a traffic ticket?
Yeah.
You know that a traffic ticket's a crime, right? Speeding. It's not a very serious crime, but it's a crime. Now, just because you're accused of speeding, does that mean you're speeding? No, it's just like any other criminal offense. You can get accused of something, but it doesn't mean you did it. You're innocent until they prove you did it. Now, with a speeding ticket, you might go, you know what? I don't think I did it, but I don't have time to mess with it. I'm just gonna pay. Well, what you're really doing when you do that is you're admitting to guilt. And so know that, it's hard to not admit to something. Sorry, I'm looking at my notes, but some of these things were already asked, like nobody knows me, nobody knows Mr. Fall, nobody knows Miss Simmons, nobody knows Mr. Evil. I did notice that there were a lot of people who have some relatives or something that's in law enforcement. Ms. Jones, your spouse, right, works for Texas Department of Criminal Justice?
Yes.
The prison guard?
Yes.
Does that have any? Oh. Just because it's a prison guard doesn't mean that you would automatically think that Samuel might be guilty.
That has nothing to do with it.
No. But you said a minute ago that you didn't think you could be impartial in a DWI case because your friend was killed,
Yes.
and I'm sorry to hear that. To be candid, my sister was killed by an alleged drunk driver in Fort Worth. Years ago, well, actually on Thanksgiving Day. So it's very emotional, right? So it'd be hard for you to do, wouldn't it? To be able to sit and give Samuel a fair shot, or would you be thinking about your friend?
I can give him a fair shot, but I would want to be as impartial as possible. And I wouldn't want that to creep in and cloud my judgment.
Right. And you're pretty sure that it wouldn't?
I'm sure it wouldn't.
Okay. Fair enough. And I think Ms. Landry, is it your stepson's a prison guard?
Years ago.
Years
not
ago,
now.
no longer. But, that wouldn't affect anything having to do with this case, right?
Not at all.
And Miss Caraway. Who was it that, oh, your son-in-law was in law enforcement?
No, I was,
Oh, you were?
yes,
Oh, I'm sorry. Where did you work?
Baytown,
Baytown PD?
yes.
Oh, okay. Did you retire from it?
No, I left there. I was a patrol officer from 1986 to 1990.
Okay. Is the fact that you were a patrol officer and what you saw as a patrol officer tend to sway you one way or the other with respect to whether you would give a patrol officer more or less credence than anybody else?
No, I don't think so.
No? Okay. It's funny, I'd say it's funny. I did a trial in Liberty, Texas. And there was a big panel, it was a felony case, serious case. And I asked them a question. Does anybody here is there anybody here who wouldn't automatically disbelieve a police officer just merely because they're a police officer? And only one gentleman held up his hand. And I went, oh. And he was way in the back. There were so many people, such a big court room, that there was no way that we were gonna reach him. He couldn't possibly be a juror because of the way our system worked. But I wanted to ask him anyway. I said, why don't you believe? Why wouldn't you believe a police officer? And his answer astonished me. He said, because I used to be one. And I went, okay, that's interesting. So you hear a lot of things, and so that's why I asked. You might have some reason to think you'd be more inclined to think, believe them, and you might have some reason like he did to be less inclined. Mr. Holmes? Is it Holmes? Is he still here?
No, that person was here, number 10.
Oh, number 10 is gone?
It never appeared.
Oh. Okay. Sorry. Mr. Brochette. Your sister-in-law's a retired deputy,
Right.
and where was she deputy at?
Orange County.
Orange County? How long ago did she retire? Do you know?
6-7 years ago.
Did she ever tell you, or did you ever talk to her about, stuff?
Nope.
Okay. So the fact that,
Stuff. That's it.
huh?
Family stuff.
Yeah, I get you. She didn't tell stories about her work.
No.
And so nothing, the fact that she was in law enforcement doesn't have any effect on
No.
whether you would, be fair to Mr. Paul.
Mr. Mason, you have 4 more minutes.
Thank you, Judge. Mr. Allen.
Boucher, like the water boy.
Oh, I'm sorry. If I mispronounced your name. Mr. Allen? Who in your family is an FBI? Cousin? Okay. Are they around here or somewhere else?
Out of Atlanta, to San Antonio.
I'm sorry, I didn't hear you.
Was in Atlanta, but now
Atlanta.
he's in San Antonio.
Okay. My understanding is that the guy get hired, they moved you someplace different than where you're from, for whatever reason. At least that's what I think, but I could be wrong. Does the fact that was in FBI have anything to do with whether you could be a fair and impartial juror?
That's his job, that's not mine.
Right. But my question was, you can be a fair and impartial juror, right?
Yes, I had to be military.
You have 3 minutes.
Just, thank you, Judge. Mr. Baker, your dad's a warden, assistant warden?
Mhm.
In Ohio.
Okay, yeah.
Are you? But being a warden, that's not the same as being, well, it's indirectly, but they're not like patrol officers.
Right.
We're worried about other problems or issues. That wouldn't cause you to have a thought one way or the other as to whether Mr. Falk is guilty or not. Right?
No.
Yeah, 2 minutes.
Thank you. The last thing I want to talk about, Mr. Davis, is, I guess you're number 3 now. You're the one that had several people that were accused of DWIs.
Yes.
Were they all found guilty? Or do you know?
No, they all took a plea deal.
I'm sorry, what?
They all took a plea deal.
Okay, so they were all guilty.
If it's what that means.
Okay,
I don't believe they were,
okay.
because I was in the car.
And you work for the Texas Department of Criminal Justice? Is somebody, oh, your cousin works for this? Or did I write that down wrong? I guess I did.
Minutes.
Anyways,
No one I'm related to works in law.
okay. I appreciate y'all's attention, listening to me. We all want a fair and impartial jury. Because if we don't have one, then our system doesn't work. So we appreciate you being here. We appreciate your attention to our questions. And we look forward to presenting the case before you, the ones that end up on the jury. Thank you very much.
Ladies and gentlemen of the panel, the prosecution and the defense have finished asking the questions here at court. Now, we're gonna ask that you go back out into the hallway. There are two doors, you can go out either door. Now, we may call some of you back in for some follow-up questions. Okay? So at this time, the court will be in recess. Will everyone please stand as a panel? Exit the jury, exit the court. Your excuse.